My name's Anne-Marie Foord. I'm currently the Director of Professional Standards at the Law Society. I have quite a varied background in the legal profession. I've been a judge's associate, a barrister, in-house, and now currently running the Professional Standards Department, which is regulatory but also corporate. Interestingly enough, I think John took quite a few of my comments. I think it's really important that we do stick to a principles base of regulation, that we aim to state our objectives as high as we possibly can. I think that's the best way of ensuring that whatever regulation we have in whatever form is going to be useful in the future. Interestingly enough, in terms of supervision, I see that as one of the issues too for the future, that the failure of the legal profession to grow and to supervise its under 2-year professionals is really, I think, going to be manifest in another 5 or 10 years when those younger practitioners are out by themselves. And I really see that as something we should be putting more resources into. Technology can really be used to help supervise. I think the use even of just email files and documents between a supervisor and a young solicitor can be really a useful tool. Remote supervision for some of our outlying areas. I know out in the West there's loads of difficulties with young solicitors who go out there very altruistically minded but find themselves really challenged by the fact that they don't have enough support. And I think Skype technology can really be used to support those younger practitioners. In my area, we also deal with unqualified practice, which is obviously the opposite side of the provision of legal services. As I agree with John that a definition of some sort would be useful as to what the provision of legal service is and what is legal practice. We've dealt with that recently in the Law Society, and it's becoming increasingly common that someone will ring up and say, usually a solicitor say, these people are providing legal advice, and it could be an accountant or a download of a document in relation to a shareholders agreement or a will or whatever it is. Our view in the department, and I must state here that I speak only for me, not for the Law Society generally, is that, if you start modifying that document at all or giving any advice as to what should be in that document, then you're providing a legal service. However, we haven't had any court cases on it yet, well, not in my 6 years here, because the complaints just don't come through about it. And I agree with John on that we don't know where that will that was purchased at a news agency and wasn't written correctly, we don't know where that's gone. We don't know how that shareholders agreement collapsed or didn't collapse. It's just not information that comes to us. But I do believe that there's a role of the Law Society, and we should be playing it in educating people, educating the community about what their rights are and really what the role of a lawyer is and how the lawyer can assist them. And I think, I'm just going to finish on this, lawyers are incredibly bad at communication. I've consulted a lot of professionals in my life, architects, doctors, dentists, whatever it is. They really do not fail to communicate with you about what they're going to do and how much it's going to cost you. And at any given time, they'll tell you it's changed and it's going to cost you more. And I think we really need to go back to law school and teach our young lawyers how to communicate, and that having those conversations up front rather than running away from them is actually part and parcel of being a lawyer and providing that service to your client.
Are you also of the view that the role of the regulator should not be trying to apprehend trends with a view to changing regulations, but in effect waiting and seeing what happens?
I think if we tried to apprehend it, we would spend an awful lot of effort that may be misguided. We have limited resources. I think they're better put in trying to deal with what we've got and trying to ensure, as I said, that any regulation we have is put at such a level that it can incorporate whatever changes are made. So with technology, we have, I was looking at it the other day, a rule about keeping documents. And I was thinking, well, that was based on a paper-based system, of course. But if you are running your practice completely electronically and you say, well, I've saved this document and I can keep it, do you then have a duty, say if you saved it on a floppy disk, which some of you will remember, some of you won't, do you have a duty then to ensure that you can have a mechanism of playing that? Because I don't know anyone that has a computer that has a floppy disk in it now. So you have a floppy disk that is the record, but no method of retrieving it. And I think maybe, there needs to be a little nuance in the rule to say that not only do you have to keep it in a form that can be retrieved. I mean, just little things like that probably need to be nuanced, but the requirement to keep the document would probably cover it.
Can I give you some advice if you ever have to
retrieve
read what's on a floppy
disk?
They sell the readers on eBay for about $19.
There you go. Yeah. Okay, that was a bad example. I'm sure someone will have another one.
No, but I take the point, and also whether or not what you save it on is still capable of being read.
Yeah, it
in
complies.
5, 6, 7 years' time.
Yeah, I think that's just where technology has jumped, and we haven't even thought about it yet.
Yep. Can I go back to this question of supervision? You're talking about remote supervision. It does seem to me that with flexible work practices becoming more and more the norm, the ability to supervise someone by being in close proximity to them no longer applies. Is this going to be an ongoing issue, trying to properly supervise somebody, for example, who is working in the country but nevertheless providing services to a firm in the city?
Yeah, it's a good question. I think the requirement that supervision be adequate is really what you go back to, that principle. And what is adequate supervision? I mean, I was talking to a young lawyer today who, and this is a very familiar scenario, is scared to death of going into the corner office to ask the partner. Now, they're in proximity, but I would query whether there's adequate supervision. Whereas the remote lawyer who's able to email a document in and then pick up the phone and discuss it is probably being more adequately supervised in a practical sense. So you get to that, does it have to be proximate or does it have to be real supervision? Does it have to be supervision where the outcome is that the junior lawyer feels that they're being mentored, that their work is being reviewed, and that there is a quality of work being given to the client? And I think you look at what the point of supervision is before you look at the means by which it's carried out.
John McKenzie talked about the possibility of mandatory continuing legal education, including a technology subject. What are your views on that?
Well, there's already a component that requires you to develop your business skills. I don't know that I'm into mandatory. I don't know that really helps people, because it's almost like with the mandatory ethics. The second you say it's mandatory, almost people think, oh, I don't want to do this. I think it's more about educating the profession as to why you would want to do this, how technology can help their practice, and trying to get into the small practices, and particularly where technology can help them, and saying it's low cost, it's efficient, it can be used in this way. Business skills, it falls under that. So why wouldn't you want to educate people as to the use of it?
This again is probably in the territory of crystal ball, but the future of legal services and the profession, what are your views about that?
I think one of the problems we face in New South Wales is the number of lawyers coming into the profession, the number of lawyers doing their minimum 2 years and going out into sole practice. And that's of tremendous concern to me, because I think although 2 years is a minimum supervision, I don't think 2 years supervision equips you for sole practice. I think increasingly we're going to see legal services being eroded by, we've already seen accountants are stepping over in the tax area, the download of documents, wills, whatever it is that somebody can reduce to a document and put on the web is going to erode into legal services. So I think that concerns me too, because it is an access to justice issue, and quality shouldn't be determined on what your income is. So I think we as regulators really need to be looking at that and saying, well, where is that line where someone's crossed over into the provision of legal services, and making sure we hold that line so we look after those people who are the most vulnerable.
Have you come across any instances where complaints have been made against lawyers who have been involved in what I describe as a mopping up process, that they've had to look at a document that has been acquired online from an information provider, but then themselves been the subject of a complaint because of advice that they've given in relation to that document?
Not in terms of a lawyer being then the subject of complaint, but I've certainly spoken to a lot of lawyers who have mopped up what has been given to a client online, and then the client has said, "Oh, I think I've done this," and the lawyer, has rung me and said, "What can I do about the provision of this service?" And I said, "Well, there's nothing you can do about that, but they're just telling us so that we're aware." And I think that's a big issue, because then the lawyer's trying to fix something that really didn't necessarily need to be broken. It could have been probably a fairly simple transaction, but is now going to cost the client a lot more money. But I think that's also education, and lawyers should be on the front foot, educating the community about what a saving it can be to use a lawyer at the first instance.
Yes, just on supervision, I find it's a very interesting area. Quite a few hearings ago, we heard about how the requirement for supervision was a barrier to entry, particularly for people who could only work part-time or were, for one reason or another, not able to hold, say, 2 years of continuous employment, etc. Do you see that also, given the volume of graduates and perhaps the much less volume of legal positions which are subject, which enable somebody to get that supervision, do you see that as a big challenge, and how supervision requirements may be able to flex?
It's not so much a challenge in respect of supervision requirements. I think it's a challenge for our young lawyers that they can't get a senior solicitor to take them on. There just aren't jobs there. And so what's been happening is a lot of them have been given, not a lot, I shouldn't say that, but enough for me to actually say this is a trend, are getting jobs where they're not being paid. And we've certainly referred a few lawyers to the Fair Work Commission and said, that's not appropriate. And or where they're a new hybrid where they're being contracted to the firm has come to me recently, and we've had to look at that and say, no, you can't contract an employee. You have to bring that person in-house and, pay their workers' comp, pay their wages. And, the solicitors who are trying to do this don't have a cash flow to enable them to employ someone. So they're thinking of new and innovative ways to get around it. So I think it's a question of volume, and that we just can't absorb the number of lawyers coming in. And so therefore some people will not get adequate supervision at the start.
So
that was
just
depressing.
to clarify that point, they're contracting with solicitors who are on restricted practicing certificates?
Yeah. Rather than employ them.